Ottawa. I give about 1 or 2 talks a year. I've been practicing with Smart and Biggar for 16 years. My focus is trademarks, copyrights, strategy and acquisition and protection, but also I do a lot of enforcement. And I'm the head of our internet law practice group. And so today's session is really focused on IP, specifically trademarks and copyrights. We won't be discussing patents and designs so much, and how it engages with the internet. All right, so I'll share my screen, see if this works, because I do have this PowerPoint. All right, so if anyone can't see it, you should now see the PowerPoint presentation, but if for some reason you can't see it, then maybe send a chat function, and Kyle, you can pop up.
Yeah, it looks good on my end, but yes, if anyone has any issues, just let me know.
Yeah, and Kyle, I've just noticed the way my screen is set up with the presentation, I don't actually see the chat box anymore. So you'll kind of have to, I'll either pause after each section to just go like minimize this screen and check the questions, or you could always interject, because I do want to answer any pressing questions. That's kind of the most interesting part of it sometimes.
Yeah, sounds good.
All right, so I could probably talk for about an hour on each of the 6 portions of today's presentation. So necessarily, this is an overview, and I'm really hoping that you'll just either it'll be familiar to you and you can pat yourself on the back and say, oh, we're doing great, or there'll be some new ideas on how you could potentially advance your level of IP protection and thereby grow value for your business. But I will warn you that it's a little dense if you're a non-lawyer or you're not already experienced in this area, but I hope you're going to like it. I want to start off with a few true stories, just to kind of whet your appetite on some of the things that pop into my practice on a weekly or daily basis. So the first story, imagine you work at one of Canada's largest, if not the largest, insurance company. You're in customer service, and the phone rings, and someone says, I've been in an accident. Here's my policy. What do I do? And you're looking it up, and you can't find the policy number. You try the last name. This person is not in the system. So you tell them, I think you have the wrong company. We're not your insurer. And they say, no, you are. And they screenshot, they take a picture of their policy, and sure enough, it is a doctored insurance policy. So of course, you immediately say, how did you get this? And they send you the email chain where they received a 30% off insurance this week only. Email looked very professional. They called the number indicated, and they gave their card details, gave their credit card information, paid $1,500, which was quite a bit less than they would have had to pay. And they received a PDF of what looked like a complete insurance policy. In fact, it is an insurance policy, because you were able to match it up and realize it's some guy from Niagara Falls, but somebody got a hold of this policy and just changed the name and the VIN number and the car and the model and the date, and has emailed this person. So essentially they have just a worthless piece of paper. But of course, if one person responded to this email campaign and is driving around and been in an accident, there's probably hundreds that might have fallen for this online scam. So that's one example. Here's another example. Some of you might remember a few years ago, Trump kind of ripped up NAFTA. Renegotiation was going to happen, and Canada did its, I don't know, they called it like the charm offensive, and they were constantly sending people down this, tight negotiation. So one of the sticking points was milk origins. I'm not an expert on why milk is such a big deal, but I think you'll probably all recall that this kind of protected industry was a bit of a big deal. And a Facebook post comes up alleging that your products all use US milk, and they call for a boycott, and it goes viral. And employees are upset, customers are upset. What do you do as a company? You got some fake news here. Third example, you're an innovative company, small little company up in Oakville. You come up with a product where you can pour juice into it, and it's literally a juice box, but it does not spill when you snap it shut. You can flip it open, and then you can drink your juice. So for card chips, this is amazing. I actually have this product because you don't have that empty juice box that sits and dribbles all over the place. But you're a bit of a high-end product. You're trying to get it into, kids stores, baby stores, and you realize on Alibaba that there is complete counterfeit lookalikes at cheap prices, and it's killing your market. So what do? I'm going to tell you at the end what I did to solve these three problems after we've kind of learned some of the underlying bases. But what I will tell you now is that each of these examples is an online trademark or copyright infringement. And they can all really be resolved by just owning your trademarks and copyright and having a plan to deal with the internet. So here's today's agenda. I've got 6 points I'm going to run through, probably spend about 10 minutes on each of them, and then that'll take up an hour. And if there's questions, I'll answer those. And if not, we'll end a bit early because I think there's an hour and a half booked. I'll read them out. Why is IP important? What are the types? How to own your IP, how to protect it online, tracking and enforcement, and risk reduction. Let's jump into the first one. Now, maybe I'm preaching to the converted, but when you work at a law firm that's 130 years old with 400 employees, and we only do one thing, which is IP, morning, noon, and night, we're kind of drinking the Kool-Aid on IP. And we're Canada's largest IP specialty firm. But I've had companies from Google's level all the way down to a startup not recognize the value of it. And sometimes it's only when they get burned that they maybe refocus more energy on IP. So I'll just give you a little taste of why I think it can be valuable. So the first is the fact that if you look at the Standard & Poor's 500, just as a metric, it accounts for 75% of the total equity of companies in the United States. So it's the vast majority of the entire US equity market is the S&P 500. And a 2015 survey pegged 84% of that whole value of the entire S&P 500, if liquidated, was in these intangible assets, primarily IP, primarily patents, trademarks, copyright, trade secrets, and all these things. So for big companies, it used to be around 75%, but it's going up towards 90% of their value is actually in these intangibles. It's not a brick and mortar world anymore. Here's a definition of what IP is. Sometimes people don't really have a handle on it. This is my definition, but based on a lot of things that I've read over the years and my practice. So intellectual property rights are the method of turning an intangible that every business already has. You can't really be in business without coming up with ideas, creating content, having a brand, developing a reputation, having some confidential information. So you already have these things, but it's the method of turning those intangibles into a form of enforceable property right with a concrete value. If you don't pursue certain steps, you actually won't own this stuff. But if you do the necessary work, you can own these intangibles, and that's valuable. So what kinds of things can you do once you own your IP rights? I've put that at the bottom of the slide. These are just a few examples. So the main one that you're probably kind of aware of is that it provides you with a monopoly. You get market exclusivity. When J.K. Rowling wrote Harry Potter, why is she a billionaire? I believe she made $1 billion. It's because she's the only one, through her publisher, that can make copies of that book. She wrote the first one, and then with her publisher, they made 50 million copies and sold them. But nobody else is out there selling Harry Potter without her permission or without the royalties going back. Or take Viagra. For about 10-year run there, they had a valid patent, and nobody sold Viagra or sildenafil, the drug. The Viagra is the brand name. Nobody could sell that except for them. So Pfizer made a killing on this drug. And I've got a water bottle here. It's an Nalgene water bottle. You can kind of see the trademark there. I love Nalgene water bottles since I was in college. They're super strong and they work really well, and they don't even cost that much. They're the only ones who can put that name on a water bottle, and it's valuable. They sell more, and they sell them for more money. So that's the first benefit of IP, is giving you these market exclusivities. The next interesting thing you can do is, of course, you can buy and sell it and license it. This can create a lot of money. If you look at certain companies like the Star Wars franchise, they actually only make a little bit of money on those movies. 90% of the money they make is the merchandising, or something like Pokemon. It's selling the lunch boxes and the sheets and the stickers and all that stuff. So you can license and merchandise your stuff. You can franchise it like McDonald's, but of course you can buy and sell it. Think of IBM. They made laptops some time ago, ThinkPads. At some point, they shifted and they said, we're going to be a service company. We're not going to make a single physical product. It's too competitive or there's no money in it. But they didn't just let ThinkPad die. They didn't let the brand and they didn't let the patents die. They sold it to a Chinese company called Lenovo, who needed that boost to get their up and coming laptop market going. And so they were able to sell their IP rights. That's pretty much all they sold, and they made a lot of money on it. Enhancing valuation. So companies will sit there in the equity market and then, oh, guess what? Our insulin or our vaccine passed stage 3 clinical trials, and the stock price goes, but that stock price can't really rise if you don't have patents, because developing a drug that anyone can use once you've done all the research isn't really worth anything. So by having your IP protected, when people come to invest in you or buy you out and do the due diligence, it's actually just enhancing your equity value, even if you don't even have a product yet. So you can't really, it's a future market exclusivity. And I've got two more here. You can use IP as collateral and security for loans, and tax optimization. Probably everyone has heard about this concept that, like, why doesn't X big company pay any tax? Why do all these American and Canadian companies pay no tax? They put a head office in Ireland or the Bahamas. There's some sort of moving of money. Like, what's happening? It's pretty much a license for the IP from the Ireland head office, which has a very, very low or no tax, and they license it to the American company so that the profits that would normally be generated get reduced because they're paying the licensing fees into the no tax. So IP is a key way to control tax obligations on a global basis. So that's the end of my little presentation on, like, why does IP matter? Of course it matters. And if you're a small business, I thought this was interesting. I read this last year. Some study said for just the average business, like we're just talking about the average little business, it's 40% of your value. And most of them don't know how much it is. They haven't pegged a number. It's not on the balance sheet, and they're completely undervaluing it. Okay, I don't have the question box, Kyle, so I don't know if there's any questions yet. That's really just the introduction with the stories and why is it important. I'm now going to kind of get more into the meat of the presentation.
Yep, nothing yet.
Okay, great. So let's go over the types of IP. I understand I've got 30 people on the line. There's a range of experience. I won't spend much time on this, but I want us to understand what I'm even talking about, because the number of times I've had people call me and ask me for a copy mark or a trade patent, it's a lot. A trademark is just any symbol that can distinguish your products and services from somebody else's. And I've given you a little box there of just 5 of McDonald's hundreds of trademarks. You can have many, many trademarks for one brand. So the first one is the word McDonald's. They own that for restaurant services in Canada. Nobody else can use that name. And then the next one I've given you is a sound mark, ba-da-ba-ba-ba. It's those 5 notes, A, B, C, E, D. Then we have the golden arches, and we have their tagline, I'm loving it. The last one is the golden arches, and maybe you can't see it, but the word McDonald's. So it's a combination of the logo and the word together. So those are trademarks. They're just symbols that allow you to be like, oh, I know who that is. A patent protects new, useful, and not obvious inventions. I love the Lego patent. For 20 years, only one company pretty much in the world, wherever they had patents, could even legally produce Lego. And the key to that invention was the tubes which connect into the empty space in a releasable fashion that, a child can physically push them together, but then they come apart. It was a difficult thing to do, and they got a patent on it, and those patents are now expired, but that gave them this 20-year monopoly to build a brand that is Lego. And you can buy no-name brand Lego, but honestly, how many of us regularly buy that? Copyright. So trademarks are symbols. Patents are ideas. Copyright is expression. It's the expression of an idea, but you do not own the idea. Okay, that's a common misunderstanding. J.K. Rowling doesn't own the idea of boy magicians. Anyone can write that book. There's thousands of them. But it's the particular expression. It's the words she used, the phrases and the language. It's covering software, photographs and drawings, images, video, all text, books, brochures, websites, music, more, the shape of buildings, architectural designs. So copyright is protecting that expression. Moving on to trade secrets, super valuable. It's any information that you know that's not easily publicly, you can't just look it up on Wikipedia. If you know something that other people don't easily know, keeping that secret produces value. So this is know-how, data, customer lists, proprietary procedures. Think of Amazon. They actually have secret procedures to minimize the price of shipping a package by taking the product, knowing its dimensions, and having a computer design how you're going to get it into the box. And it's not necessarily weight. Sometimes they have to reduce the length or the width. So they know the postal rates, they know what boxes are, they know how big their products are, and the computer tells the low-paid employee how to put the things in the box with those little, styrofoam or blow-up packages to minimize shipping. That's not easily available. It's a proprietary procedure. It saves money. Finally, industrial designs. It's just the shape of things. It's that famous Coke bottle. It's the shape of the French's mustard bottle. Or I've given you this example, Crocs shoes and where they've put the holes. So that's all I have to say about the types of IP. That's a broad overview, and I'm certainly not telling you, everything about what types of trademarks, because that's a different talk that I actually give on trademarks or copyright. But I just want us to understand. So the two I'm going to talk about today are the trademarks and the copyright.
Sorry, Daniel, there is one question that came through.
Okay.
So do I need to trademark my incorporated company's name? Does incorporating automatically trademark the name?
Okay, that is a super fantastic question. This comes up literally all the time. I'm glad it was asked. When you incorporate or register a business name, that has absolutely zero benefit from a trademark perspective. It makes no difference whether you're a numbered company or you call yourself Walmart Canada Inc. or Smart Biggar LLP. That is purely so that the government in the tax rolls knows who you are and who to deal with. And there's actually laws that say if you're going to do business, you must put a legal name on your invoices. So it either has to be your corporate name, your personal name if you're a sole proprietorship, the partnership name, or a registered trade name, okay? So the fact that you went out and registered it and got your nuance search is completely zero. What creates trademark rights is only two things. If you use a mark, so if that name, let's call it Walmart, if you put it on the front of your store, that's now not just a business name, but it's called a trade name. It's the name you're trading under. It's the name that you're telling people that you are, okay? Shoppers Drug Mart, their actual legal entity name, I think, is just like a numbered company from Alberta, but they call themselves Shoppers Drug Mart, right? So when you use trademarks, you're building up goodwill and you're getting rights. The second thing you can do is register them. So if you haven't got a registered trademark, and if that business name isn't like appearing in your advertising and on your products, then you have nothing. And the fact that you get a business name is no defense to infringement. It's literally worthless from a trademark perspective. Now, that being said, like as you recognize, some people, that business name that they register, they do use it on the products. So it's both a business name and a trade name trademark at the same time. But if you just, when I look at corporate searches, I'll find like 100 companies called Paladin, and I have no idea what they do or if they're even in business or if they're public. And I don't worry about the fact that there's 50 Paladins on a nuance or business name search. What I do is I look at the trademark registry and see, has anyone registered Paladin and for what? And then I look at Google and see, are there any companies that are out there that are called Paladin? Those are what matters from a trademark perspective. Okay, let's talk about how to own your IP, trademarks and copyrights. This slide's on trademarks. The next one's on copyright, and then we're going to move on. That's all I want to talk about ownership. So these are the 7 concepts that will help you understand what it is to own a trademark. Number 1, a trademark can only have one owner. It can never have 2. If it did have 2 owners, it couldn't function as a symbol to distinguish one company from every other company in the world. Okay? Now that doesn't mean you can only have one user. There's just one owner. So if you look at the second bullet, you can license your trademark to other people. Disney licenses the Disney properties to candle makers and sticker makers, and when they license it, they have contractual provisions that make sure that Disney has kind of control over the quality. Like, this is what you're allowed to make, and it needs to meet our quality standards, and you're going to give us a royalty. And by licensing it, all the use by those other people goes up to the owner. Okay, so if I start a fencing company called Daniel's Fencing in Ottawa, and I got 5 employees and we're building fences and we're killing it and we got a great reputation, and someone in a neighboring town, Stittsville, says, Daniel, I'd love to call myself Daniel's Fencing Stittsville. Can I license your name and I'll get my own employees? And I say, sure, just give me 5% of your profits and you can use my name and we'll make a deal. That person is developing nothing for themselves. They're literally just getting deals on fencing. They're charging $2,000. They make $1,000 profit, and that's all they're doing. They're developing nothing for themselves. The Daniel's Fencing Stittsville is completely 100% owned by me. I own the brand. All the people that are being licensed are just boosting my reputation. Okay, so that's the first 2 bullets. There's one owner, and licensing, it's like a pyramid scheme. The third point is that trademarks are national in scope. Now, this is an online protection talk. Why is that important? The internet is global instantly, but trademarks are national. You constantly see these collisions. You get UGG Boots Australia and UGG Boots United States. They each own the trademark in their country. They both go online. So there's going to be a collision, right? You get Budweiser beer, 400-year-old brewery from Czech Republic, and you get Anheuser-Busch's Budweiser, and they continuously collide in different countries. In a lot of countries in Europe, you can't buy Budweiser. You get Bud Light or just Bud because of that Czech company. And similarly, the Czech company's beer in the United States, they have to call it Czechvar because they can't call it Budweiser. It's already taken, right? So they're national in scope. That means that if you're doing business in Canada and the US, you're going to have to deal with this trademark thing in both countries separately. The next concept is, who owns a trademark anyway when there's like disputes and whatnot? It's whoever used it first or registered it first. So when clients, I just had a client come in and say, hey, we're a brewery and this is our name, but there's one in Ohio with the same name. There's a problem here. And I said, okay, relax. When did you launch your business? When did you start using your name? And have you applied for it? We didn't apply for it. Okay, well, when did you start using? And when did they start selling in Canada? And who was first? First gets the prize. The 5th concept there is you should clear trademarks to avoid disputes. Clearing is what I said in response to that question. It's looking at the trademark register to make sure no one has it already. Otherwise, you'll just launch a name. And it's looking on the internet to make sure there's nothing there. I'll give you an example from Ottawa. A lot of you are from Ottawa in this talk. There is an old athletic club in Ottawa called the Ottawa Athletic Club. They've been around for like 100 years. About 10 years ago or so, a company launched in Ottawa with 4 beautiful gyms. They're called Movati today, but at that time they were called the Athletic Club. So the Ottawa Athletic Club versus the Athletic Club. Well, they didn't clear their mark, I assume. The Ottawa Athletic Club said, this is confusing. People are going to think you're branches. They complained. And ultimately, the Athletic Club had to recall every one of their membership cards and replace it with Movati. They had to remove the signage on the top of all their stores. They had to, bring back the brochures and the handouts and reprint them. They had to drain the pool and rip up the tiles on the bottom that spelled out the Athletic Club and retile the pools. So it wasn't inexpensive to change your name when you realize you picked one that was already taken. So that's the importance of clearing trademarks before you launch them. especially when it's hard to change. If it's a trademark that you're launching it, but you could very quickly online just like switch brands, obviously your risk is lower, right? 6th point, registration has many benefits. Sorry. I'm not going to go into them because that's a whole talk that I give for an hour on why you should register, why you shouldn't, how you should, best marks. I'm just telling you it's beneficial. And the last thing I'm going to say is continuously using your trademarks and controlling the reputation is absolutely critical. If you don't use your trademark for 3 years, it can be automatically canceled by anyone who makes a request to the trademark office. So you can't just let them die. And you must control your reputation. If you just let infringers take your mark without doing anything about it, it will lose its distinctiveness and it will also die. So those are the 7 hallmarks of trademark ownership, and hopefully that was helpful. Now let's go into copyright. Number 1 issue in, let's say, a company selling itself or there's due diligence, not the most important issue, but the most common problem is most companies have no idea if they own their copyright, and if they do own it, they can't prove it. And it's a I would say over 75% of companies have this problem. So maybe you'll learn something today. Authors are the first owners. The author is the physical human being that sat down and took that idea and put it on a piece of paper. I authored this in preparation for my talk, okay? So I own the copyright. And copyright is created the moment that your idea, your expression gets fixed. So if you record a song, you record a video, you write the book on paper or into a word processor, you code the software, it cannot stay in your head, and it's not good enough to say it verbally. It must be fixed so that you can like hold up a USB key or something and say, my copyright work is on this or piece of paper. So authors are the first owners. So that's the first thing to think about. The only exception is if they're an employee. If someone is like a full-time employee and they're creating work, then the copyright automatically, under the law, automatically goes to the employer. Okay, that's the only exception. Otherwise, you need an assignment. So any marketing company you hire, any contractor, any third party, any partnership, anything that's created, even founders of companies who are not necessarily employees, they'll draw a logo. You know, oh, I founded Snapchat, I'm drawing the ghost logo. It's the founder that owns the logo, not Snapchat Inc. He's not an employee necessarily. Some of them are, some of them aren't. And so you need to get an assignment. But the Copyright Act says no assignment is valid unless it's made in writing. So you 100% of the time, when you create something, a video, a movie, a brochure, a website, need to get the actual authors to sign a simple 1-paragraph thing that says, I'm assigning the copyright in this to the company. And you got to do this all the time. So here's my 4th bullet. Know the authors. The number of times that I've said, who are the authors? And they say, well, I don't know. It was our marketing department. Who? Was it Jim or was it Sally? Oh, well, we hired a contractor. That's great. How many employees do they have? Well, they have 50. It's a big digital marketing agency in Toronto. Who was the author? Give me a name, Joe Brown. So whenever you're buying product, you need to include in your contracts, please tell us the name of the author. And let's get in the agreement that the copyright will be assigned to us. So the 5th point is, unlike trademarks, and frankly, unlike patents, designs, this is unique to copyright. It is international. You own the copyright automatically without doing anything, without registering it, and in the whole world, the moment you put it ink to page. It's amazing. You create something that's yours, you own it. But you got to know who was the author, and you have to have an employment contract that shows their name and proves they were employed during the day they made it, or you got an assignment. I've already covered the 6th point. It exists the moment of fixation. So it has to be original. And what original means is not that it's creative or new. It just means that you yourself didn't copy it. Now, the fact that I draw something, if I'm copying something, I don't get copyright in my version, okay? But if you're sitting there being creative and you create something and it originates from you, then it has copyright. And my last point is registration optional. So that's everything I wanted to tell you about copyright ownership. And hopefully now that you understand a little bit about how to own your brand and copyright, you've already kind of upped your game.
So Daniel, there was one question that came through. So could you repeat what you said about not protecting your IP for 3 years?
If you register a trademark, which gives you a coast to coast to coast national monopoly over that name, let's say it's Nalgene for sports bottles. So that's your monopoly. No one can, or McDonald's for restaurants. If you were to stop using the trademark, which means you stop putting it on products, or if you're doing a service, you stop putting it, on your business card or your website for 3 years continuously, then it becomes vulnerable to what's called summary cancellation. I can write a letter to the office saying, I think this mark's been abandoned, and the trademarks office will issue a letter requiring you to prove your sales in the last 3 years. And if you didn't have any, your trademark dies and then someone else can come and take it. So this is a way to clear off deadwood, bankrupt companies, marks that have been abandoned, old things. And in Canada, we always warn our clients that there's a 3-year non-use risk. The moment you have 3 years of continuous non-use, and this happens all the time. I mean, think of the Smurfs, right? That was a TV show, but then eventually the Smurfs kind of died out. And if there's no toys or anything for 3 years, that trademark could just die. Okay, so hopefully that answers the question. Just ask again. I'll answer any question.
So one more came through, sorry. So a global company like Google needs to trademark their name in every country they operate in?
Absolutely. Honestly, if I could absolutely effing positively. So you think to yourself, you guys all read the newspaper. You've probably heard stories about Starbucks going into China or iPad going into China. And some Chinese citizen said, oh, Starbucks. And they filed an application for $250 and they already owned the trademark 5 years before Starbucks went there. And too bad, so sad. You didn't have any stores, so you weren't using it in China. And they registered it first, so they own it. And so you have these companies buying back their marks for $1 million in China or India or Europe because some ass registered it and trolled you. So you absolutely need to register your trademarks in every single country in the world if that's where you're selling. Now, there's a cost benefit here. I don't register trademarks in Bahrain very often or Kenya. They have bad legal systems. It's a minor market. You wouldn't necessarily do it. But with one of my clients, they sell a nutraceutical. Like imagine something like Cold FX, like it's kind of a health product, okay? What they do is we have the trademark in Canada, United States, all of Europe you can get in one shot because the EU, and China. So we have 4 countries. But every time some person says, hey, we'd like to be your distributor in Chile. People love your product. We want to distribute. Okay, great. If you want to distribute in Chile, we're going to make a deal. We'll send you tens of thousands of dollars, but we're going to set aside $2,500 to get a trademark in Chile, and you're going to pay for it, my distributor. Or maybe they split the cost. So you can expand over time as you enter countries. And the decision on whether to kind of blanket the world in trademarks before you get there, kind of defensively, that's kind of like it costs money, right? So it's a balance. And I would absolutely say any country that you're selling your product or you have a manufacturing arm, which is a lot of the problem that Apple ran into with its iPads in China. You can't even make the product and export it if someone owns the trademark. That's where you need to really protect yourself.
Do you want to do one more question before we move on?
Yeah.
So how much does it cost to trademark?
Depends on the country. Like kind of a minimum fee in Canada, if you hire a firm like ours, it'd be like $1,600 to own a trademark. But every logo, and you saw McDonald's, right? They have many. But that's the minimum fee. Often there's little challenges and problems. So a realistic figure might be $3,000 to own a trademark, but you own it forever. You just have to renew it every 10 years, but it's very simple. It's like a domain name. Once you have it, it's yours if you keep using it, right? So super valuable. In other countries, maybe in the US, it might come to 5,000 with exchange rates, all of Europe, 4,000. So you know, it depends on the mark and the country, but it's a few thousand. Now, if you want to try it yourself, just the bare government fees, you might only be $500 out of pocket. Because obviously we're charging on top of that $500, you know, 1,000 to 1,500 in our fees, right? So if you wanted to try it yourself, I usually recommend not to dabble in things you don't know, but sometimes people have literally no capital, and so better to try it yourself than not register at all, right? You know why IP is important? You know the types, you know how to own it. Let's talk about the guts of what might you do on the internet to not get screwed, essentially, to really accelerate building your brand. So the first thing I often say to people is, someone might want to sit down and make a plan. How are we going to be online, right? My law firm has what? A website, Twitter feed. Like, how are we online? Home Depot has a commercial store, right? So there's different ways to be online, and I've got some bullets here. You can have your own website. You can have a social media presence. Maybe there's customer review websites like a TripAdvisor or something like that for your field. You might be offering an actual product and service online. Now that could be through your own website or through platforms. You may have third parties like that move your product, like Nike. Like their products are available at Sport Check. Maybe they also have Nike stores. You might have both. You may choose to have your products either directly, or some of your retailers and distributors might be putting them on platforms like Amazon or Alibaba. A lot of people, even if you're just running a store, like a barbershop, maybe you have a lot of online advertising. Maybe you have targeted, you know, email campaigns or Facebook advertising or Google AdWords. And maybe your business is literally like lives on the internet. You're like Netflix. It's software as a service. So depending on where you fall on how you engage with the internet, your strategy might be a little different. And in this slide, I talk about the questions I would have if I was to do a 30-minute consultation with a client. Frankly, to really get into this would take hours and hours, but I might ask them some of these questions. What are your key trademarks? Which ones should we register? What countries, if any? Do you have your copyright under control? What about notice and marking? So one of the best and easiest things you can do to protect your trademarks and your copyrights is to tell everyone, these are my trademarks and copyright. It's called giving notice or marking. And I'll show you on the next slide how to do it. You can secure, I mean, this is obvious, right? Get the domain names that match your trademark, certainly your key trademarks, right? You know, you can go to generalmills.com, and you can also go to cheerios.com, which is just one of their products. And Procter & Gamble has a website, but they have websites for each of their, like Tide and, you know, whatever Procter & Gamble makes, right? Like Always tampons. So they have the separate websites for different brands that they have. So domain names plus social media. The fifth bullet is super important. I could do a whole talk on just this one bullet. You should have terms and conditions. This is one of the best ways to protect yourself. You should have terms and conditions to use your website. So if you have a website where people can post things, what does your terms and conditions say? Who owns that content? Does the authors, that's what Copyright Act says. It says the authors own their content. Maybe your terms and conditions say, if you post something here, we have the right to use it. You own it, but we have the right to use it. That's like what YouTube would say, right? You own your YouTube video, but we have the right to distribute it. And by posting it, you're giving us a license, essentially. What can you do with it? Think about the MLS. Like when you go on the multiple listing service to look at houses, there's always these boxes like, click our terms and conditions, prove you're not a robot. And it'll say, don't scrape our website, don't steal our data, don't do this. Those contracts that you click through and the terms of use have been enforceable in Canadian and US courts, okay? So you can actually control a lot of your stuff by just getting a contract and just letting it sit there and making it a precondition to even interact with you. the sixth bullet I have there, copyright digital protection measures. So don't just make a contract, because yeah, you have the legal right, but people are idiots and people steal stuff. So, you know, have cookies that track, put up a paywall like the Globe and Mail does. If you're going to give people a sample, let's say they can develop a logo online. When they have the sample, put like a crazy watermark in it that they can't remove. So they actually have to pay the fee to get like the high quality JPEG versions. So the more digital protection measures that you put in, it just makes it less opportunistic and easy for people to infringe. And by the way, the Canadian Copyright Act was amended a few years ago to give legal effect to digital protection measures, and it's actually against the law to try to break them. Okay. Contractual limitations. I'm actually now talking about your distribution chain. This is both trademarks and copyright. Limit where they can sell it. I had a client, they do high-end menswear, so high-end suits. They were selling to, like, you know, let's say Harry Rosen or something, but they never thought that their suits would show up on Amazon. Someone had too many suits and they discounted them and they went online. That was not part of their business model. They don't want their suits available online. They want you to have to go in and meet the people. And if it's going to be online, if you're going to buy a Louis Vuitton handbag online and not in a high-end store, it's going to be on the head website, the Louis Vuitton homepage. They don't want their distributors hawking their stuff online. So if you want to have geographical, country, province, channels of trade, price minimums, Apple doesn't let people ditch their laptops for $1,000. They have very strict price ranges. Now, some of these things would be anti-competitive. You can't always control everything that your distributors do, but this is a really great way to protect your IP. You're controlling the quality, the character, and how it's distributed. And the last thing I put there is anti-counterfeiting and anti-contract breach tells. So a lot of companies at almost no cost, like my nutraceutical one, when they make their product, they put a little number for what country it's going to, and or what distributor it goes to. And then they can tell if the product is going from their West Coast distributor back into Ontario, because when they see the bottle, they'll say, hey, this has a number 2. Number 2 will only sell in BC, Alberta, and Saskatchewan. What's going on here? So you can put all sorts of little tips and tricks into your products to easily detect counterfeit. And that's really helpful when you then have to go and enforce, which is what's next. So let's see. I'll do the notice and marking, and then I'll pause before the enforcement for questions. Here's how you do notice and marking. On the left-hand side, you've got trademarks. To provide notice, you literally just tell people it's your trademarks. So you could say all trademarks on this website are owned by my company. Or if you're licensing it to someone, say, okay, tell them the trademark is used under license. The trademark Daniel's Fences Stittsville is used under license from Daniel Incorporated. It provides notice to people of who's the brand owner. Sometimes you'll see these things if there's like cross branding. You know, you got a pack of Doritos and they have a contest and it shows like you could win a PlayStation or you could win like a Honda Civic. They'll say something like the trademarks are the property of their respective owners. So notice is really useful, okay? And sometimes people will use like a star or like a sword beside the trademark, and then you have the notice somewhere kind of discreet. You can put that on your website, or you could put it in a brochure, or you could put it on a product. Marking is a little different. Marking, you're putting it like right there. So you would have like brand TM or brand R. TM, you can do anytime you want. If you think it's a trademark and you think it's yours, you just throw down the TM. The R is restricted for marks that have been registered. You must achieve registration to claim the R. And you can put TM after words that your lawyer says, I don't think you could register that. It's too descriptive. It's the name of a country. You can still put TM and just tell people, hey, I claim this as my own. Even though I can't actually legally register it, I still want you to know, stay off my lawn. There's a principle in trademark law that if you make something well known enough, you can overcome those descriptiveness obstacles. So example, how did Molson own the word Canadian for beer? You can't own the word Canadian. You're not allowed to trademark country names. You're not allowed to use common words like that. Well, they used it as a brand. so much that anyone who walks into a bar and says, give me a Canadian, the person doesn't say, well, what kind of Canadian beer do you want, sir? They just put a Molson Canadian. So if you can prove to the office that you've acquired fame in a mark that initially wouldn't have any trademark value, you can actually own trademark. So they would have put the TM during those 5 years that they were building their brand, and then they would register it. Moving on to copyright, you could give a notice or in your terms and conditions like, hey, all, I've said material, all pictures, all videos, all whatever is subject to copyright protection and can't be used without express written permission. You see that all the time at the end of broadcasts on liner notes. So that's notice. And then marking, it's literally this easy. If you've got a brochure or a website, you just use either the C symbol or the word copyright, your legal name, and the year that you created it. And then you've told the world that it's copyrighted. And that actually opens up additional damages if people take it anyway. So I'll stop now for questions before I launch into part 5 and 6 of the talk.
So one question came through. So for a global B2C app, social media platform, do I trademark in North America, Europe, China, and Oceania?
Oceania doesn't have a one trademark, so that would be country by country and it'd be awkward. Well, not awkward, but you'd have to pick countries like Australia. So the question was a B2C, which is business to customer. And then what did they say? It's a software app?
So B2C app, social media platform.
Okay, so a B2C social media platform. So what I would recommend is, where are you based? If you're Canadian, you got to get Canada. Next, what is your budget and how far can we go? If you literally only have $10,000, I would do maybe US and Europe. But if you've got a bit more money, then, or we could do it over time, right? So it's going to be kind of a question of budget. But in an ideal world, I would register the trademark of your social media app in any country where you had significant user base. So if no one's using it in China and you're not running it through Chinese servers and you're Canadian, maybe you don't need it in China. That said, China is the worst country for trolling. So if you have a 3 or 5 year plan to get into China, then yes, that would be a really positive defensive registration. So the answer is essentially, it's a combination of, you got to get your home office of where you are. You have to have that. And then you go as far as you can go on budget. And the question of where you go is, where are your markets? So even a company like, even big companies don't register in 200 countries, okay? Like if I think of a client, like a substantial $100 million client, they might have a portfolio of Canada, US, Europe, China, and India. And then if a particular market's popular, or they go in, they might get Korea or Japan or Mexico and go beyond that like that. Hopefully that kind of answers your question. I can't really give legal advice in this. It's just, that's a general answer, but certainly a lawyer could probably sit down and plan that for you. IP is a bit tricky. There's a lot of people who dabble. So good legal advice at the beginning can save a lot of costs in the long run. It would be my recommendation.
Great, thank you.
Tracking and enforcing, and then I put evolve. It's a little bonus there. So what do I even mean here? I told you, all of you are going to own your stuff, right? You're going to clear and register your trademarks. You're going to mark them. You're going to have your copyright assignments. Everyone's going to be like gold standard. They're ready to sell themselves, ready for due diligence. And you've done all these protection measures about warnings and terms and conditions. But no matter what you do, people still rip you off. In fact, the more famous you are, the more they rip you off. So you can't just stop there. There's 2 types of tracking. So tracking is checking what's going on, and then enforcing is doing something about it. The first kind of tracking, I call it proactive. You're watching on purpose and seeing what's going on. So you would track your own activities. This is super useful when you have to prove to trademark offices around the world that you're developing a reputation. If you have to sue someone, the evidence that we will need is how many people visited your website? What were your sales? What is your advertising? We're going to ask these questions. So nowadays online, it's pretty easy. Get some robust analytics. And so that you're tracking what you're doing and you're monitoring the marketplace. So monitoring is a bit different because tracking would be like people buying your stuff and engaging, but monitoring would be seeing how many times you're referenced in the media, checking on your kind of footprint globally. So you could do that internally, or you could hire some company to kind of monitor your reputation and what's happening in the marketplace. Any substantial company will have hundreds of references in the news and whatnot, and that's not something that you can just automatically track internally. You have to kind of like monitor that. And the hallmarks to a good monitoring plan are that it would be regular, so monthly or weekly or efficient. I've seen people waste a lot of time monitoring. You need something that's like easy and hopefully cheap. Comprehensive, so try not to miss any huge swaths of what would be important to you. Like maybe your brand is discussed a lot on blogs or here. So you kind of have to know where your brand is on the web to monitor what's happening to it. How did that company I told you at the beginning find out about that milk post, right, on Facebook? They had to monitor not what they were doing. They didn't track what they were doing. They had to monitor what other people were doing. And I say cumulative because I've had companies that write to me every month about the same problem. We need to have some sort of memory of what we're seeing and how we dealt with it. So that's the proactive. You're tracking and you're actively monitoring. Then you have a reactive, which is you're letting people tell you about stuff you missed. If you have really good tracking and monitoring, this won't happen very much, but it happens, definitely. So external. You should try to let people know, maybe at the bottom of your website or something, where to complain if they see something. You'd be surprised at how many clients with like fan bases, they'll say, hey, dear Shopify or dear Lululemon, I saw this and it's counterfeit and I almost got tricked and you should do something about this. So people will complain and your retailers will complain. I just had a client. They said, our Turkish distributor is complaining about a website that's popped up that pretending to be the real thing. Let's say it's Honda Motors, and the Honda Motors Turkey distributor is saying, someone's got a website, Honda Motors Turkey. What are we going to do about this, right? So your distributors and your retailers and your customers, they're all going to be telling you stuff. And then you have internal, like let your own staff and your sales force, when they spot things in the market, who do they tell, right? There's companies that are good at this. They have centralized feedback. And there's other companies that they find out about something 5 years after, but they realize that all their employees knew about it, but nobody knew who to tell about the problem. So this is the concept of tracking. But now what do you do with all the complaints? Like you get so many complaints. Honestly, as soon as your company becomes big, it's like a never-ending list. How many times do you think McDonald's gets a complaint about somebody who's done something, or they make a t-shirt that has like an M, but it's made to look like private parts of a person or something like that, right? So what I do is I tell companies to triage internally, or if they're using my services to kind of farm it out, then I would do it with them. I use a red, yellow, green. So red means this is a serious problem. I'm going to do something about it right now. Yellow says, okay, it's annoying, but I don't know if it's hurting us. Maybe we just write a letter and see what they say, or maybe we just watch it. It's kind of like not mission critical. And green, frankly, half of them are usually green, is where you say to them, you don't own copyright and ideas. I'll give you an example. I had a company that was an arborist. They go to your house and they plant trees, trim trees, cure your trees. They're tree experts. And they said, if we come to do a property consultation, we'll bring you a free tree. How much does a tree cost to them? $20. So it was a free tree with every consultation. And so they advertised that. Choose Daniel's Arborist, free tree. And then a competitor started offering a free tree. And they say, hey, stole my idea. Well, you didn't patent the idea of a free tree and you wouldn't be able to. And it's not a trademark. And there's no copyright. So there's literally no IP. There's nothing to stop someone from doing what you're doing. That's just called competition. And so I say that's a green. And then they say, okay, and they forget about it. And so that's probably half of the cases. It's your employees think it's a problem, but then your lawyers will tell you that's not a problem. Now, let's say it's a red or a yellow. There's 4 ways to engage the problem. So the first is direct. You would engage with the infringer if you even know who they are. Sometimes on the internet, it's smoke and mirrors. So you could just send a request, send a letter. You could negotiate with them. Often, if the person is just kind of innocently infringing, they will just stand down immediately. And you can escalate it with a kind of a more formal C&D letter as well. And ultimately, you can sue them, but we'll come to that later. So because it's the internet, the beauty of the internet is you literally cannot be on the internet without going through a hub, an ISP. So here's the types of ISPs I'm talking about. Social media, that's an internet service provider. They're providing a forum. You can engage with them. Or a retailer like Amazon. Hosts and registrars. Every single thing on the internet has to go through a registrar. There has to be a domain name, and they have to have a host. It could be the same entity. Some registrars like GoDaddy, they also offer hosting, but sometimes they're separate. Payment processors. If they're making money, they have to go through PayPal, MasterCard, American Express, Visa, something. And they have a coalition where they will actually cancel the payment accounts that have been set up and freeze the money when it's fraud and counterfeit. So you can actually engage with them and turn off the money. It can be very effective. So I do this all the time. And yesterday, a Japanese company, like the 3rd richest guy in Japan, he contacted us because his foundation for scholarships was someone had come up with a scam website and was sending phishing emails offering speaking engagements. They looked really real. And it was just a big scam to money launder and bilk people. And so I engaged the host, which was Wix. I engaged the registrar, which was Network Solutions. And in about 3 hours, we'd shut down the whole thing. Okay, so that's ISPs. Public and partners. Sometimes you can't deal with the problem. It's like little counterfeits that are here and there, and you just can't, it's not cost effective to get rid of them all. It's just kind of like that noise, right? But you can inform your customers, like if it doesn't have the green circle, it's not an Algene, or a lot of loyal customers will want the real thing. And you can inform your retailers, you can inform your distributors, like watch out for this, or this is how we have to pitch it. So sometimes a public education plan is helpful. For example, I often find illegal products entering into dollar stores and Walmart. And we tell Walmart, hey, this is counterfeit. If you want to carry our products, just so you know, they're only available from these 2 distributors. And if you're getting it from any other source, it's fake. And then Walmart says, oh, well, yeah, we're sorry. Our buying agent thought they could pick up some, I don't know, Ralph Lauren t-shirts. We didn't realize that you had such a controlled supply channel. We'll know in the future that if someone's selling Ralph Lauren t-shirts and it's not distributor A or distributor B, that's probably fake. So you can educate your retailers and distributors, and that can really cut off the taps, okay? And then the final way to enforce is you go to authorities like courts, UDRP domain arbitration. You can register with customs. You can complain to ad standards councils, competition bureau. There's a whole bunch of legal bodies that can resolve complaints. And maybe you might even include ICANN in there. You can complain to ICANN about certain domain practices. But my golden rule is if there's no harm, if you look at it and you say, this is not devaluing our brand, this is not causing us to lose sales, it's just a technical infringement, I say do nothing. You've got enough problems to worry about. So I've seen companies try to go after fan clubs, or they try to just stop every infringement, and it's a bottomless pit of money and it's worthless. Let's just go after the things that matter. Finally, and I won't spend any time on this slide, when you have a serious thing that happens, or just annually, I like to review everything. I review ownership. Do we have ownership? I review our policies and our marking, and I review our tracking and enforcement. So you just take a few hours once a year and you ask yourself the question, could we have stopped some of those infringements? Could we have had better rights? Maybe I need new trademarks. Maybe we need to update our contractual terms. Maybe we need to expand our monitoring scheme. Maybe we need to have better education. Maybe we need to be adding password protection or anti-counterfeiting tells, or retrain our staff on guidelines. Okay, so that's super useful. Another example, there was a company that they do online obituaries. It's like a major funeral home chain. And there was this company scraping their obituaries and republishing them. So you'd find the obituary not just where you meant to put it, but you'll find it like all over the web. And then they try to sell you like an everlasting flame. You pay $10 and they create like a little digital image that just waves that you can go look at. So by adjusting the terms and conditions of our website to say that no one is allowed to download this data and republish it, we're able to create a legal right to shut that company down potentially. Okay, so that would be an example of reacting to something that's happening. And the reason you can't always apply copyright in that case is copyright is the expression, but if they just take the facts, like the date the person was born and their name, you actually can't control just copying facts by copyright. So you need a bit more. Let's see, I got one more zone. Since I've really just told you kind of about the general, you might be saying like, well, you didn't teach me how to do it. Well, yeah, I didn't, because it took me 16 years to get good at it. But here's a list of problems that are solvable, and most of them easily solvable. So this might just help you know what you can deal with. So I put there, recover almost any domain name. And I'm assuming that the domain name has your trademark in it, okay? You can't go and recover, cheapcars.com, because that's just generic. Second bullet, you could actually locate very easily every single domain name in the world, every domain name that's ever been registered that has your name in it. You can track so that you get a message whenever someone registers a domain name that has like the word Google as part of it. You can shut down email-based scams that involve your brand, like I did for an Asian client yesterday. You could find out who's behind a domain name. Now that's hard these days, but there's tricks. And ultimately you could do it with a court order, but that's usually not worth it. You can shut down a website. I'm on the second column now, if you want to follow me with the slide. You can remove content from platforms. You can cut off access to illegal websites. So our firm did this last year. It was first of its kind in Canada. We actually sued Bell and TELUS and Rogers. They didn't really defend. And we told them, we've got a big bunch of fake Netflix free movie streaming sites that if we shut them down, they pop up again. So we want you to censor them and block any Canadian who has a subscription to Bell, TELUS, Rogers from even being able to go there. And the court agreed. And it essentially was court-sanctioned censorship for this flagrant criminal behavior. You can get a handle on your counterfeits. You can address a misleading claim. If ever a competitor says that they're better, they're faster, they have more sales, and it's a lie, we could deal with that. And you can generally try to stop competitors from kind of riding on your coattails, from using your brands, from using your stuff. So those are just kind of general problems that we solve that happen online all the time. So I've got about 5 minutes left, but Kyle, are there any questions at this stage?
Nope, nothing yet.
Great. So avoiding risk. So that was really how do I protect myself? But how do I stop from being the one in hot water? I say set guidelines and vet. Vet means like check what you're doing, check yourself, right? It's not good to have guidelines that sit on a shelf. So the reason is that you need guidelines is that your content is changing. You've got new brands coming in and out. new partners, it's evolving. And you've got a lot of decision makers. And some of them have no clue about legal knowledge because that's not their job. And you really want to have a consistent way to do it because that really makes your brand grow. If you're just all over the place, it's not really the best way to grow a great brand. And you're trying to manage risk. So those are the reasons you need guidelines. And a set of comprehensive guidelines that you could draft in writing and have employees read and rely on depending on their role. If someone's running your social media account, they should know the guidelines. Like maybe it says, if I'm going to refer to a competitor's product in my tweet, if McDonald's is going to throw shade on Wendy's in the tweet, it goes to legal or it goes to a manager. That could be a guideline, for example. So here's the things I would include. I would say, well, these are why the guidelines exist. So something at the top from the CEO, these are important. Maybe how to use them, some key definitions like I've given you, like what is a trademark, what is a copyright, a section on how to do the marking, a section on how to make sure you have licensing in place, maybe a section that sets out what are the channels of trade that we're comfortable with. Like maybe you're a company that you don't put your stuff on Amazon because you don't want to devalue it and you don't want to compete against your own distributors. You have a section maybe talking about how do we pick new trademarks and who should we get to clear them and make sure they're not already taken. A section on how to be consistent in how we use the trademarks. Like this, you can't see it, but I've got a little polo logo here. They don't put it upside down, right? They don't make it bigger or smaller. It's always consistent. That grows a brand, right? It lets people see it more easily. What can you do and what can't you do with third-party materials? Like maybe you can be cheeky with Wendy's, but you can't necessarily grab their copyrighted stuff and post it on your website. Sometimes there might be a little decision tree, like this is the level that these decisions are made, but if you need advice, go to your manager and then go to this person in legal. And some way to update the guidelines. So that's how I would prepare guidelines for a company. If you wanted written guidelines, small companies probably wouldn't have them, but any company of a substantial size, this is a really great way to reduce risk. These are my top 7 tips to reducing risk, your risk of infringing. Apply your guidelines. Set the rules of engagement. Like you're going to be online. You can draft your own terms and conditions that the world has to follow when they engage with you, right? You can make up your own return policy. You don't even have to have a return policy. There's no law that says you have to have one. It's just good customer service. And so make sure you've got policies that favor you. Lock up the valuables. Like if don't have important things that people can view or download without password protection or tracking or licensing or watermarks. Have monitoring in place on what you're doing. This goes both ways. Monitor what other people are doing, but monitor what you're doing. Always use other people's IP with caution. Get permission or get someone to vet that because you're always at big risk when you're dabbling in your competitor's IP. Be aware that any strong claim requires strong support. If you're going to say you're the fastest internet in town, you're going to get hit with a competition bureau complaint or your competitor is going to take you to court if it's not supported. Okay. Comply with all regulations, language laws, contest laws, safety requirements. So if you kind of have these things in place, you can reduce the likelihood that you'll get a complaint. And when you do, since you're a good corporate citizen, you'll usually be able to just get out of it really quickly by agreeing to stop doing what you accidentally did that really got somebody upset. So Kyle, that's pretty much the end of my talk. I'm just going to finish off because I got 15 minutes left. I'm just going to give like 3 minutes on the stories I started with, like how they churned out.
Yeah,
But
so
are there any questions at this point?
there's none now, but I suggest if anyone has any questions while Daniel dives into these stories, and then we could come back to them, please put them in the Q&A section and then we'll cover them. So nothing yet, but yeah, go ahead, Daniel, and then we can see if there's anything at the end.
Okay, so with the car accident story, the reason that that phishing worked is because it was this insurance company. Let's make up, like, let's say Scotiabank Insurance. That's not it, but it was one letter off. Like they had a hyphen, Scotiabank dash insurance. So that's the reason why people fell for it. But that's also the reason why we could deal with it. The web host and registrar was a company called Vista Print. So I figured that out from Whois. I contacted their legal department. I actually called them right up. You can't always do that. Sometimes there's an online complaint form. And I spoke with someone and I said, we got a serious infringement. Someone 3 weeks ago registered a website that's one letter off. They've been sending email solicitations, and we've just got a complaint that someone was in a car accident with a fake insurance policy that could be hundreds. You need to immediately, there's no website, by the way, we're just using it for emails. You need to shut down this domain name so no emails can be sent or received. So all the emails they'd sent out, you simply couldn't respond. If you tried to respond and say, oh, I'm interested, you wouldn't be able to, because it would just bounce back like this email doesn't exist. And I actually was able to negotiate in that phone call that they would just transfer the domain name right to us. So literally that afternoon, the scam was shut down, was transferred, and then we just put in place a monitoring for the next 30 days for any domain name in the world that got acquired that had that brand name in it, like Scotiabank or whatever it was. Facebook drama. So obviously some guy, rightfully or wrongfully, gets this impression that a milk company uses American milk. It was false. And he's got this Facebook post and it's kind of going viral. Now, that company, actually, their president sent out a memo to the entire company that said this is not real and we're dealing with it. It was a big deal, surprisingly. If you're like me and you don't really know why milk is such a big deal. I contacted Facebook. Now, I could have said that this is a false statement, but Facebook doesn't really care about false statements. They say, oh, go to court, or oh, we have this abuse policy. Well, it's not child porn, it's not terrorism. So what are we really going to do? And how do we know what's true and false? So they're not really good at that. But what they do take seriously is copyright infringement. And the post took a picture. It had all of our products with a big X through it. I'm like, where did he get that picture? He certainly didn't go and buy our products and line them up and take his own photo. He must have pulled it from our website. So I went through the website in the Wayback Machine and I was able to find the picture that he took to create that post. Then I wrote to Facebook and said, this is a copyright violation. And according to the Digital Millennium Copyright Act in the US, once an ISP platform is made aware of a copyright infringement, they must remove or they also become liable. And it was gone like that. And of course, that individual, if he'd understood law, he might have realized that he could have reposted something but without the photo, or he could have taken his own photos or something. But once something gets pulled on, usually it just ends, and it ended. And the third one with Alibaba is Alibaba has a policy that they will remove any listing if you show that you own a trademark, copyright, or patent that appears to be infringed. Well, we didn't have a trademark, especially not in China. It would be hard to get a trademark in that name, Drink in the Box. It's a little weak. But I was able to go out and register a copyright. You can actually register copyrights. You don't have to, but you can. And it only takes 24 hours in Canada. It takes like 2 years to get a trademark or a patent. You can get a copyright in 24 hours. So we registered that logo, Drink in the Box, as a copyright, grabbed the certificate, went on Alibaba and shut it down. And then we actually created an account on Alibaba, kind of one of these like brand registry where you register your brand. And we monitored for no future violations. And in addition, we went and got a trademark in China in that name. So those are how we resolved those complaints. Most of them were done very quickly, within a few hours or a few days. But these are the kinds of things you could do to fix problems that pop up. And so, Kyle, that's really the entirety of the presentation. And I hope it was useful. And if there's questions now or later, I'm open.
Great. Well, thank you so much, Daniel. I will just wrap it up, and I don't see any questions here. So they have about 30 seconds to submit their questions before we wrap it up. So yeah, just as a reminder to those on the line, I will be sending a PDF copy of the slides and a very limited time frame for you to rewatch the session. I will be sending you that follow-up email as well, as I mentioned at the top of the session, with how to access some of our services and upcoming webinars. Yeah, and I guess I'm still not seeing any questions here, so I guess we could wrap it up there, unless you have anything else to add, Daniel?
No, I guess I can stop my screen share, but No, it's always a pleasure to kind of give a little window into what we do. I hope there was some nuggets in there that would help businesses kind of understand how they could defend themselves a little bit, their trademarks and copyright online and stay out of trouble. But this is an ongoing process. And if any of you feel like you're way down on kind of the tips I gave, like you're not doing any of it and you're panicking, don't panic. Most companies are below like best practices, and I would just recommend take a few baby steps to start with.
Awesome, great. So we just have a few people saying thank you. So still no questions. So I think we could wrap it up there. So virtual round of applause for Daniel for taking time today. And thank you to Invest Ottawa partners Smart and Biggar for hosting today's session. So we'll wrap it up there. Hope you're all doing well. And hopefully you're able to enjoy this nice weather we're starting to get. So goodbye, everyone, and take care.
Bye.